All right, good afternoon, everybody. We are on the record today at 12:45. Today's April 2nd, 2025. We are here at the request of the petitioner. We are here to have a presentation from the petitioner that will be approximately 10 minutes. We'll have a timer on their proposed alternative to AR 2025-24. This is an extraordinary offering to the petitioner to have this additional work session. And so we're going to go ahead and start with introductions in the room. Mr. Littlefield.
Mark Littlefield.
Scott Myers. Christopher Constant. On the phone, Mr. Martinez.
Yes, thank you, Chair.
Thank you, Mr. Martinez. This obviously is not the assembly, and so we're going to be careful to ensure they're making any offers or any assertions here that can't be made by anyone but the assembly. That is the judge of this question that is coming before us. With that said, we'll go ahead and have the petitioner introduce themselves.
Good afternoon, my name is Rachel.
You have to turn the microphone on. The green light will be on when the microphone is on.
Thank you. Good afternoon, my name is Rachel Lawson, with the law firm of Lawson Law Team, and I represent AlaskaSense LLC. Sonny Warden, Canada-listed Canada.
Jana Holstein, regulatory attorney for Canada.
All right, so that's fine. We also have members of community council. We have our licensing clerk here present. We have members of the community in the room. And we will go ahead and get started. Please go ahead. We'll offer 10 minutes for you to make a presentation of this proposal.
Thank you very much, Mr. Chair Constant. My name is, again, Rachel Lawson, and I was invited, AlaskaSense was invited following a discussion with Assembly Council Gates and Legislative Council Hurt to prepare something for discussion purposes, which we thought that this work session was going to be a discussion with regard to our position, with respect to our position on what is fair and reasonable with regard to AR 2025-24, and that is what I prepared. AlaskaSense's position is kind of threefold, that a conditional protest based on the fact that AlaskaSense's business was vandalized and that it hasn't gotten its permanent fix completed to its ventilation system. Although the interim fix has been completed for the top floor of the premises and should be completed with the bottom floor of the premises by this week. That would be something that, we would regard as, aligned with the facts. However, with regard to all of these statements of this poor past history with odor and 2024, that is, we do disagree with that. We also want 2025-12S to be revoked. So in particular, what we object to with regard to some of 2024-25, for example, is a statement, in the whereas, where it talks about during the license period 2023 to 25, the Assembly received comments from the public and from the Midtown Community Council regarding odor compliance issues. This document was read on January 21st of 2025. As of January 21st of 2025, the only comments from the public were a comment from Megan Debenham, who's of the Midtown Community Council, that was in Enclosure 6. And then Kenny Peterson at Enclosure 7, where he talks about his documented reports to the Assembly rep and Community Council via email. All of these complaints were forwarded to land use. They were investigated. They were unsubstantiated and unfounded by Municipal Land Use and AMCO. Additionally, with regard to these comments by the Midtown Community Council, I went and I took a look at the Midtown Community Council's bylaws, and those bylaws were just passed, and I have extra copies of the bylaws Nathan, why don't you hand these out if you can, please? Thank you. And these bylaws on Article 9, entitled Reporting Official Council Positions, it requires, first of all, Section 1, that a communication must include the date, type of meeting, general, special, executive, and when the vote was taken. Section 2 requires a clear written statement of the question voted on, the number voting yes and the number voting no. 3, written or oral communication or any contact by a government officer concerning council affairs shall be summarized in the minutes. And 4, in public testimony, no officer or member shall commit the council to a position not previously voted on by the membership. There is no record of the Midtown Community Council presenting the question at a notice meeting where we had any notice that that there was going to be a vote on our renewal. There is no record that a vote occurred with regard to our renewal. There's been no communications with various government officials, including members of the assembly, that were disclosed to us. And yet there's been public testimony purported to commit the council to a position that was not voted on by the membership. So, that's an issue that we have. Additionally, with regard to January 7th, 2025, when AR 2025-12S was passed, we received, the first time that we received notice that there was all this conversation in the background occurring between a few select people, it's almost like a secret committee, was when we received notice of 2025-12, which was like December 30th, and at that point in time, the municipal assembly had already taken the position that they were going to protest based on odor. And before the government made a private person of a protected property interest, there must be a hearing. Except when public safety, or health or welfare is at issue, which is not the case here. We did not receive any notice from the Midtown Community Council or the Assembly before the 2025-12 was proposed. This was a stigmatizing document that ended up in a possible deprivation of our protected, first of all, our constitutionally protected reputation, and second of all, constitutionally protected business interest. AMCO has tabled reviewing and approving AlaskaSense's cultivation license because they're waiting for the municipality to make its decision on the municipal license. The conditional protest has been set out in communications to the public that have stigmatized the business, due process is violated when a party shows that it suffered stigma from a government action plus alteration or extinguishment of its right or status recognized by state law. We should receive notice that there was a secret committee consisting of various individuals that have been described in the writings. And second of all, I want to point out also that in AR 2025-24, it talks about, in paragraph 3, regulation of odor is challenging given the subjectivity of odor detection, the lack of scientifically accurate measurement of odor in devices calibrated the same, the temporal nature of odor and its susceptibility to ambient conditions, and the complaint responsive system of code enforcement and availability of resources to verify and substantiate with reliable evidence from independent and impartial investigation the existence of odor and its origins. If a statute, by its imprecision, confers upon decision makers, whether it's judges, jurors, or law enforcement personnel, undue, naked discretion in determining what constitutes the violation, it's void for vagueness. And there's evidence here of arbitrary and capricious action, and the way that this statute is being leveraged, or this law is being leveraged against my client. Essentially what the Assembly is saying is that despite the results of an investigation. We're gonna throw those investigations out by neutral, objective standard and go ahead and impute our own standard, which is, we don't like this business, so we identify that they have violated odor, despite there being no findings. So that's what we have an issue about, is that, yeah, and Jana has something to say as well.
On a positive note, we had a really good discussion with the Midtown Community Council yesterday where we discussed talking about a new MOU with additional smell concern protocols. So I kind of created a template for that and fleshed out some ideas. So I'm really excited about the opportunity to work with the Midtown Community Council to renegotiate a more productive MOU. So I think that's a great positive step. And then I also just wanted to reiterate that the interim fix has been installed and the long-term fix, what was the date on the long-term fix?
We've already applied for the permits and we've submitted the claim to the insurance company. We're waiting for them to agree to it, give us the proof of loss form with the amounts, and so that we can sign it and get paid. It's supposed to be paid within 30 days after presentation of the proof of claim.
So that's great progress too. So right now the smell should be under control, but I think the key is, you know, there was a lot of good discussion yesterday about this like kind of a difficult problem to solve. This intermittent smell is difficult to kind of pin down on no one's notice. So I think a revised MOU with a really detailed structure of how to address the odor control issues when they do happen, you know, noting harvest schedules, smell logs, that kind of stuff. I think those are going to be really key moving forward. So thank you so much for your time and letting us have this opportunity.
And one more thing as well that we also presented to in the packet as well is that we've also instituted an internal policy so that we can be proactive instead of reactive and not have to rely on complaints and not disturb the neighborhood. And under this policy, we are proactively twice daily checking the air balancing. Because the reason why there's no complaints for 2 years was because the complaints before that, what happened was when we received those complaints is we went and we found out that the air was not balanced and the rooms were not maintaining a negative pressure. We called Alaska Air Balancing, had the rooms rebalanced to ensure that there was negative pressure and the odor problem stopped. So we do have a ventilation system that is capable of ventilating the premises so that the detection of odor is not able to be perceived at any area of the lot line by a person with a normal sense of smell. So we have the capability of compliance with the existing ventilation system. So rather than wait to hear complaints from the community or affect people around us, we realized that we could be more proactive, and that's a piece that I think that we have been missing, that we are willing and able to do, and we are going to do it. So that's, you know, part of us accepting responsibility in that regard as well.
So quickly, I'll just note that at 12:50 p.m., Ms. Brawley joined us. At 12:56 p.m., Ms. Brawley joined us. Do members of the assembly have any questions for the petitioners?
Yes.
Go ahead, Ms. Brawley.
So you're saying there's a temporary fix that is working well, but the last time we met, I know this permanent fix needed to be ordered and it hadn't been ordered yet. Is it on its way here or in town and ready to be installed?
Okay, so it's called an interim fix, and it's something that that we've had to get permits and get it designed by an engineer, and that had not been. It was just installed, ma'am. So it was just installed yesterday, and then the second piece of it is getting installed today.
But I think the question is the long-term fix.
The long-term fix has been also permitted. The permits requested. We are at the final. I don't know if you've ever filed an insurance claim with an insurance company, but part of the delay in that was that the HVAC units that we had, we were told that the parts no longer exist, and so we were going to have to replace the entire HVAC unit systems. And that, of course, ended up being like $1 million for the electrical and the HVAC. Then the insurance companies don't want to pay that, right? So, and we had to design these systems as well and get an engineer to do that. Then when they saw how much it was going to be, they scoured the earth for the parts. that will work for these systems so that it can be fixed. So then we had to shift gears and get a new plan in place, permitting all of that. And then we have received, we are in active discussions with the insurance company, and the funds should be here, but we want to get the funds to cover. I mean, one of the things is they're saying, well, we shouldn't have to pay for the plans that Ron Thompson designed, because when they asked for that, because that's now not the course of action that we're taking, and so that's what we're kind of like disputing.
So I think the answer is this, they've been sourced, the equipment's been sourced, but they haven't been actually paid for, and until they're paid for, that's when they'll ship.
But so we'd have to get all new equipment. I'm sorry, I probably didn't answer your question, I apologize. It's parts, and so the parts have absolutely been sourced, because that was what was contingent on us being able to repair versus replace the entire units.
And I don't want this to be really long, but before, when we met, they weren't ordered, so you sourced them, but they are not ordered at this moment either. That concerns me. I know you're waiting for insurance to pay, but this is pretty darn important. Maybe it could be reimbursed instead, but those need to get ordered.
So I think we need to be careful here. We're fact finding. I mean, we just need to be careful on what our approach is for this meeting. The work session is for fact finding, not for debate deliberation for those elements. And so we'll have a meeting in which we can do that coming up on the 8th. So I think that it's, go ahead, Ms. Brody.
Yeah, thanks. And sorry, I'll go back and watch the recording for the minutes that I missed, but just curious, because I know there's been, well, I know there's been, I'm curious, what is the status does your business have a, I can't remember if it's a good neighbor agreement or whatever the agreement is with the community council?
So we do have an MOU with the community council, and so I did write them a letter notifying them that under the MOU, we want to have these conversations. If we had known that there were these, this discussion happening, all we knew is that there were complaints and they were unfounded and unsubstantiated. And the cannabis industry is very controversial, and so people can call and make complaints and do all the time just to try and deem your business. And so we didn't know that there were these concerns because they weren't brought to our attention. And so I did, under the MOU, when the Midtown Community Council had received these complaints, there was supposed to be a discussion with us about it. And so I did write a letter invoking the MOU so that we could meet with the council and have that discussion, and that occurred yesterday, the 31st, so 2 days ago.
So I think
and
you
then
missed.
at the MOU, and then at the meeting, and the municipal ombudsman was there at the meeting as well. We all discussed the need to enter into a new MOU because the other one is from 2016, and one that's aligned with current times and appropriate for these two parties and the community.
Yeah, thank you. And I guess I was kind of thinking more forward-looking, but yeah, that information is helpful. I'll go back and watch the recording. But just to say, it seems like, and I appreciate the comment that the original MOU is from 2016, because it does seem like maybe some updates are needed. So I'll just leave that.
And Jana has also already gotten the discussion done. Like, we are very motivated to do an MOU with the Midtown Community Council. She already prepared an MOU.
Yeah, just some draft ideas addressing the having negative pressure, education to your staff, that kind of stuff. I mean, it's a beginning conversation. The Midtown Community Council is very active, and we've worked at my office has worked well with the Midtown Community Council on many matters, and this is the same template we've used before. It's my understanding that Midtown Community Council wants to create like a good template that can be utilized over and over again, and I'd be happy to help with that process.
So I am going to jump in now and say I forgot to do this at the beginning. I did have some ex parte communications from the council of the petitioner that we'll introduce by AIM when we get to the regular proceedings on the 8th. And I want to, let me get this right, make sure I'm summarizing what I've heard here. One is there's some disagreement on the reputational elements and maybe some assertions in the original resolution. Two, You are making active steps to improve your operations so that smells do not continue to run through the neighborhood. And then 3, you're engaging with the community council to establish a re-engaged working relationship. Fair summary?
I think that's fair. Or do you not, Rachel? Yeah, I guess we wouldn't characterize it as a smell running through the neighborhood.
Well,
But to address smell
that's-
concerns.
Okay.
And it's not just like reputation, I mean, it is reputational elements, I do think that that is accurate, I mean, but I wanna be more clear that, you know, all of these unsubstantiated and unfounded odor complaints, which is the only information that we had about odor complaints, is, you know, there, as you can see from your document, Chair Constant, the past keeps coming up. And so there, it references something in 2016, something in 2018. We have worked very hard to, you know, move past the past. And we, you know, do acknowledge that there was a vandalism, and we were upfront and forthcoming with the city, with the Midtown Community Council about that and how that could impact vandalism, or it could impact odor and ventilation. But with regard to, you know, all of these other 2024 complaints and all of these discussions that occurred behind our back that were unsubstantiated and unfounded, we specifically, you know, object to any finding that we're an odor producing, you know, a serial odor violator.
So that's the area you're going to spend your time on, rather than the making active steps and engaging with the community council. Thank you. So
No,
I would
I
say I'm tasked with actively repairing, we're actively trying to repair the relationship with the council.
So
Absolutely.
there was an assertion made here today that this whole process is being done by quote, because quote, we don't like this business. Where do you find that in the record?
Well, the record actually, I did, so originally when the meeting was supposed to be set for March 7th, and then it was supposed to be an administrative hearing, which I don't think would be inappropriate, considering the potential deprivation here. But I did say that I wanted to then subpoena all of these ex parte communications that have occurred between various assembly members about Ms. Warden and her businesses with members of the community. And then the meeting was changed to a regular assembly meeting. And so, I mean, where do we have the evidence of it? It's in records that I'm supposed to get, but also, you know, based on what you guys have done. I mean, what you said at the assembly meeting that we had in January, the way that you said, you know, the way that you talked to Ms. Warden and the way that you referenced her business, the fact that there's been proposed change to a policy to create a new policy to have police officers drive by the business and label her business an serial odor violator, when based on unsubstantiated and unfounded complaints, and saying it doesn't matter, people shouldn't have to live in a cloud of marijuana smoke, and that an unsubstantiated, unfounded conclusion is an offensive term that makes the complainant feel like a liar, and the business a sense of righteousness and justness, and their attorneys.
Okay,
those types
I
of
think
things.
you've made your point. It's very interesting. We'll discuss that on Tuesday. Mr. Gates, Mr. Hurd, can you please describe for us when the proceedings become ex parte?
So with regard to this body, it's because you have a function as a legislative body and as a quasi-judicial body, depending on the item that's before you. The prohibition on ex parte communications really can't attach until the item is set for you to take it up. It's a weird position that you're in as engaged members of the community, but you don't have notice that a particular license is going to be coming before you, it's not really reasonable to ask you to not engage. That would basically cut out whole swaths of the community for you to not engage with anybody who's potentially related to an alcohol or marijuana license, because it might come up at some point. So until you have notice of that item coming before you, I do publishing on the agenda. I don't think it's really practical or realistic to say that the ex parte provision can attach sooner.
Okay, and then a second question for council to investigate. There is an assertion made under state law that certain actions can only take place if there's a threat to public safety, health, or welfare. Can we do some analysis internally of whether heavy, dense industrial smells can be considered public health or public welfare threats?
Not right now, no, not on the record.
Can we do some research?
Yes, sir, absolutely.
Thank you. Okay.
I don't think that there's a finding that there's heavy, dense industrial smells of marijuana that share.
I agree. I don't think there was a finding yet. But, okay, thank you. Are there, yes, please.
Yeah, just a brief comment. I know it's the policy and practice of this body that we do not speak to motive. And so I would ask that everybody participating in this tread carefully when saying things that you believe or that we are doing in terms of our motive or intent. And I will say personally as well that I communicated this to the deputy clerk. I have not had any ex parte communications prior to when that went into place or before with licensees or with members of the community on this. So I just want to state that on the record. Thank you.
Karen, Ms. Barber.
Thanks. You laid out three things there. The second one was something about neighbor.
No, so I'll just restate it. It's one is there are concerns. You can frame it however you want, constitutional, reputational, material concerns about the process. Two, that they are making active steps to improve their operation in terms of air management.
Okay.
And then three, they're engaging with the community council to ensure a working relationship going forward.
Okay, I thought you said something about a better relationship with the neighbors.
Yeah.
And I wanted to add that there's several businesses that have had concerns, so it's like neighbors and businesses in the area. And I haven't had communication back with any of them, but I have read emails that have come through.
Yeah. Okay.
And we're also going to engage more with the Midtown Community Council as well in terms of like attending meetings regularly and engaging with our neighbors better as well.
That is wise. So are there other questions or concerns? So I will state that there is a proposal from the petitioner for an alternative resolution. There is the original resolution. We will have this before us. There has been a request to move this item up in the agenda so it doesn't happen late at night. That will be subject to the will of the body and the conversation. When it gets to us, we'll go ahead and allow the petitioner closing comment. I know we had an hour, but we don't need to use an hour. The idea is to just get your document in front of us. So you want to take just a couple minutes to conclude the conversation before we adjourn this meeting.
Well, first of all, I want to thank everybody in the assembly for taking the time to give us an opportunity to have a discussion. Alaska and AlaskaSense are committed to this community. They do, a lot for the community that, in terms of like giving and in terms of employing people, and we don't take that, our privilege to operate for granted, but it also is, a protected right. And we would like to have the chance to open up lines of communication with everyone and demonstrate, that, as we have been doing until very recently, go back to where there's not any complaints about our business. And we're going to take that, responsibility very seriously and ensure that. And that's what we have been doing and had been doing. And, you know, the ventilation system is something that, you know, is affecting us economically. We have no reason to not repair that. It is causing, is significantly hampering our ability to earn revenue, which is part of the reason why we don't have a lot of money to just invest and hope the insurance pays. You know, obviously, you know, that you buy insurance for a reason and you want to be able to use it, and we have to maintain, you know, as best that we can and keep our people employed, but we have a significantly reduced growth. And, you know, Smotty, do you want to say something? Okay.
I mean, I would just say, just because I've worked with Sonia for a long time, she's incredibly grateful and honored to be business in Anchorage, and she's really hoping that this is a step in a better direction. You know, in October when the vandals came and destroyed the HVAC, it was devastating, heartbreaking, and you know, she had experienced some damage at her home due to vandalism, and so they've been arrested, and so that's great. But now we have this fallout, and so it's really incumbent upon us to take the responsibility to build stronger relationships with the community members, and that's our goal, you know, and to fix the issue. And so that's why we're here, and that's why we thank you for the prolonged conversation about it.
All right, if there's nothing further, we'll adjourn this question. I'll be back before us on the meeting of the 8th, sometime after we get through the consent agenda, so after dinner. So thank you.
Thank you.
Thank you for the records.
No, we don't get to talk.
I think that there are members of the community council. So
Do I need to do it in writing so that you can read it?
again, I guess we'll continue this record just briefly, not to provide testimony, but yes, your comments in writing are wise. I would say use your 5 minutes wisely, and then members can ask anybody questions when we are convened. And so I think that the reality is that if there's any unanswered question in the minds of the members, there will be more time. Really, it's going to come down to that when we're convened.
So this is a fact-finding work session then? I'm super confused because it seems like sometimes when we have meetings, they'll say, well, this isn't fact-finding. And is it fact-finding or not? Because you just said that it was.
What it is to get your comments on the record, the document that you have provided for us, and these words that have been spoken into this record are part of the record that is going before us. But our work sessions are not opportunities for debate, are not opportunities for assertions of member positions on questions. They are opportunities for gathering facts before we convene in the hearing and take action. That's our standard procedure. There's no deviation from that here. So, but again, the council is recommended to participate in the public hearing, not going to be given time here today. So, any further commentary? We'll go ahead and stand in adjournment.
Don't